It's Russell King again with Tom Ray here in Chattanooga. Tom's a former Chattanooga attorney, expert in bankruptcy. Tom, I wanted to ask you about this issue of disclosure and non-disclosure. What's the effect of someone who is in bankruptcy not disclosing to the court that they have had a personal injury claim?
Well, what happens is you have a wreck, have a personal injury claim or some kind of claim. You then go and file a bankruptcy case. When you file that bankruptcy case and you fail to disclose it, you have taken a legal position and then of saying, I don't have a claim. You failed to disclose it. So when you then come back later and try to claim the money, on the other case, in the pending personal injury case, the courts hold that you are judicially estopped to proceed with that case.
So if someone's in bankruptcy or if someone files and they've had a car wreck, they don't disclose that they have a car wreck and they file their bankruptcy thinking they haven't gone to court yet on the injury case.
Or they haven't even filed.
Maybe haven't filed yet. And so they go ahead with the bankruptcy, maybe get their discharge, and then later on try to make that claim, to collect on that claim. Then what could happen to them? And I know you said that could be a criminal issue as well.
Could be a criminal issue if there was a criminal intent to fail. What normally and how this comes up is what they do is they don't realize they've got a case. They haven't even talked to a lawyer. Somebody had a wreck and they haven't thought about it much. And then they start having problems, and then they go to the bankruptcy, they file a case because they know they have a lot of medical bills arising from the wreck. They file a bankruptcy case to discharge the medical bills. Then they decide, well, maybe we should file a case. By then, they've actually then forgotten about the bankruptcy, and they don't tell the personal injury lawyer about the bankruptcy. And then it becomes a major problem of being able to both collect on it. Even if the trustee is able to collect, they have a problem of being able to claim the exemption because of failure to disclose.
So the injured person may not get any recovery because of their failure to disclose to their bankruptcy lawyer that they had this injury claim potentially, at least at the time they filed their bankruptcy.
Correct, and that can be a problem.
And just to sum up, whether you're in Tennessee or in Georgia, if you filed your bankruptcy one day and after filing the bankruptcy have a car wreck the next day, that's not part of the bankruptcy.
Should not be. It
generally would not be.
Right.
Because you've already, it's what you had at the time of filing.
Straight bankruptcy.
Straight bankruptcy at the time of filing. There's nothing to disclose because you hadn't had the wreck yet.
Correct.
So you have the wreck the next day, the next week, the next month. That shouldn't be a part of the bankruptcy, at least under most circumstances.
Right. But if they're in a Chapter 13, they need to be sure and disclose it to their lawyer.
So regardless of when the wreck happened, if you file the Chapter 13 and the wreck is pending, or if you have the wreck during the course of the Chapter 13, you need to tell your bankruptcy lawyer, your Chapter 13 bankruptcy lawyer, I've got this case.
Correct.
And failure to disclose could result in losing the money.
Losing the money, not being able to get the exemption, and possibly losing your discharge if it was done intentionally.
Don't want to do that. You always want to disclose. And I think, like you pointed out, a lot of times the bankruptcy lawyer and the injury lawyer are two different lawyers.
Correct.
And you don't want those two to not know about each other.
Right. Very good. Very good.
Good point. Thanks for coming in.
Yes.